My name is Susan Argo. Thank you for everyone for letting me be a part of this today. I've heard criticisms about the Commonwealth that there is no case law in Kentucky. Well, I'm here to tell you differently. We have 50 minutes, which will cover probably about 33 cases, which according to my math gives me about a minute and a half per case. Some I'll touch on more in depth. For example, Jevich, the Supreme Court ruled yesterday, and I think that would be of interest to people. They reversed the Third Circuit. So all of the summaries are in the materials there. I don't want to sit here and just read case law summaries to you, but I do think that there's a vast majority of issues that have come up that are very interesting. From my bio, I think you can tell that I'm on the creditor side of the law, so I kind of break these out, bad guy, good guy, in my synopsis, but I think that there's a good split of cases as we go through this. I've broken them out according to the Supreme Court, Court of Appeals, and then the BAP and other bankruptcy cases. But starting off with the United States Supreme Court, Husky International versus Ritz, I think that that's a good case for the lenders, and in particular what it deals with is when you're seeking to have a debt deemed non-dischargeable under 523 of the Bankruptcy Code. The court in the lower courts actually held the creditor to a standard where when you're seeking it, it's obtained by false pretense, a false representation, or actual fraud. And the background of the case was that Daniel Ritz was the owner of a Chrysalis corporation. He had transferred hundreds of millions of dollars to companies that he controlled, and he was sued then by Husky for fraudulent transfer. The court found that he did not make a false representation, and therefore, even though under Texas law that he would have been held accountable for fraud under their state law fraudulent transfer case, that because there was not a false representation, that the debt would not be deemed non-dischargeable. The Fifth Circuit affirmed that, and it went to the Supreme Court in a 7-1 decision with Thomas dissenting. They actually followed the Seventh Circuit, so there was a split in the circuits here. But I think it's a very important case for lenders to understand that there is not the requirement that there be the false representation. This falls in line with the common law concepts of fraudulent transfer. I know that Kemp Barber is going to talk about Kentucky's changes to that statute. So keeping in mind that you can use, in the context of fraudulent transfer, the old claim is that no scoundrel comes out and says, aha, yes, I defrauded you. There's not a lot of the smoking gun, so you use the badges of fraud, you use other circumstantial evidence to prove that, and the court has opened up that analysis going forward with respect to those type of claims. In the next case from the Supreme Court, so yesterday, you can take a big red X and just mark it out in my materials because the Third Circuit was reversed yesterday. It was a 6-2 decision. You had Alito and Thomas dissenting on a very technical ground, saying that the cert that was granted was not the question that the court decided. But otherwise, in Jevich, what you had is a trucking company, and to the extent you want a good explanation of what a leveraged buyout is, I kind of chuckled when I read the decision yesterday. You can see the law clerk charting out exactly what a leveraged buyout is. But at the end of the day, you have Sun Capital Partners, who's the primary secured creditor through the leveraged buyout. There were limited assets of about $1.7 million, and they cut a deal with various creditors, including the administrative professionals in the case, and they cut out the WARN Act claimants, which were the pension truck drivers. And the reason why Sun did that and chose to do that is they were being sued under the WARN Act in the case. And the case had been going on for 2 years, and the attorney in the underlying case said, we're not going to fund a party who's suing us. The Supreme Court actually picked up on that quite precisely in its decision, but what happened is the takeaway is in a Chapter 11, there's 3 ways that a case can be resolved. It's either through planned confirmation, conversion to a Chapter 7, or a dismissal. And so this concept of a structured dismissal came out, and from this settlement, what they did, they went to the bankruptcy court and said, we want this case dismissed, and we want this settlement approved, and the structured dismissal provided for payments that violated the absolute priority rule. And the court looked at the, I guess, status of the case, found that there were such dire circumstances, and that if this wasn't approved, that the case would be converted and that no one would get anything anyway. The Supreme Court reversed that decision. The Third Circuit affirmed it, and they really looked to the sacred concept of priority of payments in bankruptcy. They looked to 727 and they looked to 1129B and for Chapter 11, and that there is an order, and what we all know is the absolute priority rule. I'll tell you, I was at a luncheon last week with Dan Dooley, who was the Chief Restructuring Officer for Jevitz. He was talking about this case, and it's interesting, the background facts that you don't glean from the case law out there. They really went to extraordinary lengths to structure the settlement, and so while it seemed as if these Warren Act claimants were perhaps being left out in the cold, I think the reality of it is when you're a secured creditor, it's your money. SunTrust could come in and say, I get everything. And so I think that the takeaway from this case is that secured creditors, they'll just do it post-bankruptcy. They'll just dismiss and settle it outside. The real dialogue, though, is what is the impact of Jevitz on ongoing Chapter 11? I think that, obviously the case just came out yesterday. There's been some commentary, and I was on a call yesterday about it, that it's not going to impact first-day orders. It's not going to impact critical vendors. It's not going to impact key employees. Those are all circumstances where the absolute priority rule isn't followed. I think the other thing that was missing here when you read the analysis is there's no recognition of payment for administrative professionals. They just gloss over that issue, but who am I? I'm not sitting on the Supreme Court, but I think it certainly is a great decision if you want to, look into the priorities and just, strict construction of what the code provides under 725 and 1129B. Moving to the Kentucky Court of Appeals, we have this Baldwin versus PBK bank case. I would say I was surprised. This puts an extreme burden on lenders to really look at the underlying transaction and understand what was the purpose of the loan. In this instance, the bank gave a loan to a woman, and in the loan documents itself, it was for rental property, it was for commercial purposes, and then the loan went into default. The borrower sued, saying that she had not been given the TILA disclosures. What I also find is interesting is that there was an assignment of rents and leases given with this, but what she put forth was an affidavit saying that she purchased this home for her parents, that no rent had ever been received, and that based on that, it made it a consumer transaction. Under the court and underlying case actually granted summary judgment for the lender, looking at the face of the loan document, saying that the borrower had looked at the loan documents, had signed it, acknowledging it was for a business purpose, and granted summary judgment. The Court of Appeals reversed and was very critical of the lender, saying it was form over substance, that you don't just, that the loan documents don't dictate. As a lawyer for a bank, that leaves me kind of scratching my head when the borrower signs documents acknowledging that it is for a commercial purpose. But they said that the onus was on the lender to ask follow-up questions, that they should have understood that she bought this for her parents, that no rent was being paid, and they reversed and granted the TILA award. So what happens when you don't give disclosures? There's experts who are going to speak on this later on in the afternoon who are much more well-versed than me, but essentially then there are certain damages, statutory attorney's fees and the like, and that gets offset against the loan. So, for lenders out there, I think you really got to take that additional step to understand, notwithstanding what's in the documents themselves, that you're really, I guess, digging a little bit deeper. The next case, this one I kind of geared as who was kind of watching the shop for KeyBank. I think it's interesting facts. It's a very good case that breaks out Kentucky's view of foreclosures, but what happened in that case is Chase Bank filed a foreclosure, and KeyBank had a second mortgage. KeyBank was named. KeyBank did not enter an appearance. KeyBank was defaulted out. There was a husband and wife who were obligors on that note. The wife filed bankruptcy, and so prior to the decree in foreclosure being granted, KeyBank then decides to sue the husband on the note alone. It's certainly, based on the outcome of the case, that was its rights, but the debtor at that time then filed a motion to dismiss that case, claiming that it was a compulsory claim and claiming that it was res judicata because they did not appear in the foreclosure. Interestingly, the court combined and said that the note and the mortgage were one and the same, and dismissed the case. On appeal, the court rightfully points out a couple of things procedurally. A cross-claim in Kentucky is actually a permissive claim. So there is no compulsory cross-claim, because when you look at the status of the case, all that KeyBank could have done in the foreclosure instituted by Chase was come in and file a cross-claim against the borrower for its default. And then more importantly, they go into Kentucky foreclosure basics, that a note and a mortgage are actually separate instruments, that a lender can in fact choose to sue on the note and mortgage together in one action. They can just foreclose the mortgage, or that they can sue on the note. But I think that they really go into a good analysis of the distinction between a note and a mortgage and the remedies that are available there. Probus versus Bank of America, there's a lot of litigation that we see in my practice about the proper party and interest. I think this is a good case for that. I think you always got to have one of them. I also note that I give kudos to the attorney for the creditor in this case. They had filed 5 previous motions for summary judgment that were bounced on various technical reasons. On the 6th time, the court denied their motion, saying that Bank of America had not proved that it was the owner and holder of the note. The facts told otherwise. The court then goes into a very good analysis of the ways in which you can have standing to enforce loan documents. They note that the note was transferred from AWL to BAC, and then what had happened is BAC was purchased by Bank of America. So you get into the issues about what an allonge is, what a blank endorsement is, and then just merger concepts. And at the end of the day, the court goes through all 3 of those analyses and then comes out with that actually Bank of America had proved that it had standing in all 3 ways. The only defense that was put forth through the borrower was that this blank endorsement was suspicious. It's not. It's a very common tool that's used, and I understand in robo-signing and all of that there's a large scrutiny on the holder and to make sure who the proper party and interest is. But at the end of the day, a blank endorsement, if you're the holder of it, you're the holder of the note. So I think the court really kind of goes into an analysis and there that would be useful for you. This next case, police and fire retirement systems, this speaks to subordination issues. There was a multi-million-dollar mortgage that was granted to the police and firemen retirement systems. Interesting, I've not seen a provision like that. If you go to the case, I've not seen a lot of provisions or subordination language in mortgages like the one that existed here. But interestingly, it said that in the future, they would subordinate to a first lien claimant should the need arise. It did not address specifically who that would be, how that would be, or any of the terms. Notwithstanding that, a year later, and I think that that's critical, for the court's determination here, that there was a second mortgage for about $500,000 that was granted. Subsequently, the borrower defaults. And what the second lien claimant did is look to that subordination language in the mortgage and claim that that was applicable to their loan and that they were in first lien position, and the court accepted that analysis. The Court of Appeals reversed that decision, and it goes into a good, description of the actual terms that are needed, but that if you want to enforce a subordination, you have to have them the maximum amount of the debt that's being subordinated, you have to have the interest rate, you have to have those key terms. And so the court, what was unique to me is that normally subordination agreements that I see, it's the creditor signs it. And in this one, they hadn't, and they just imputed it kind of unilaterally over. But to that extent, such animals are out there. But this, I think, goes through a good analysis of what would be needed in order to enforce that. Parker versus Key House Corporation. This one I would say would be good for the lenders. It's a statute of frauds case. I think we all deal with these quite frequently. You're restructuring the loan. The facts of this case is that they entered into a number of forbearance agreements with this borrower, and it provided, that should she default or if it should not be extended, that the original terms would apply. They got to the end of the line, they got to an impasse, and they decided not to extend. The borrower claimed that she was promised that the loan would be extended and that the interest rate would be reduced. The court rightfully looked to the statute of frauds and says when such key terms are in play, being maturity and interest rate, that those must be in writing, and that she couldn't rely on alleged oral or verbal promises to the contrary to modify the loan. Temple versus Community Trust Bank, that goes into a large discussion about a renewal note versus novation. This left my head, I was a little perplexed by the facts. So you had a first mortgage and a husband and wife, and then what happened is the relationship between the husband and wife deteriorated, and the husband forged the wife's signature on a second note and mortgage to that same lender. There was an acknowledgement by the lender that perhaps there was a forgery, but what she then argued is that that second mortgage was a novation and that she should have been released. And so the court gets into this analysis of a renewal note versus novation, which I think is very important for everyone to understand when those attacks are being made. And at the end of the day, what they said was that the first mortgage that was not fraudulently obtained actually secured all indebtedness, and that she could not prove that that there was an ovation of that original obligation, and so she was held liable at least to the extent on that note. It left me wondering how she could be liable for the fraudulently obtained or signed second mortgage, but that the case really kind of doesn't go into that. But it is at least a good discussion of renewal versus novation. And then there's additional case that I just became aware of that is not in your materials. I can give you the site for it. It's Brooks versus J.P. Morgan Chase, and it's 2017 Kentucky app, Lexus 121. Court app, it's February 10th, 2017 case. This one I thought was interesting. There was a mortgage that was held ultimately with a note and a mortgage by J.P. Morgan Chase. The mortgage was signed by the husband, not the wife. The mortgage didn't have a prepared by signature. The mortgage didn't have a legal description, and it was not recorded and lost. But nevertheless, the Chase files a suit on the note. They then file a lis pendens and seek to reform this horribly defective mortgage. I give them big kudos for courage when I looked at all of those factors. Notwithstanding that, what happened after the suit was filed, that this particular borrower then gave a mortgage to a law firm for legal fees. And it was recorded, and I think the key thing for the court was that it was recorded after the lis pendens was put of record. So what the court found is that this was actually an equitable mortgage, that they really looked to the fact that that lender had provided credit and that there was supposed to be security there, and that the law firm who took the second mortgage was actually put on notice by virtue of the lis pendens. So this one, I think, goes a long way. I don't know that I've seen such drastic, efforts with respect to a mortgage, but I think it was a big win for the lender in that regard, on that. So you may want to, just keep in mind that case. We'll go into then the Court of Appeals for the Sixth Circuit. With this one, you have Village at Knapp's Crossing and Pioneer Ventures. With this case, really what was happening was the debtor's case was converted from an 11 to a 7. It had a big shopping complex that was its primary asset. And what they did is appeal that order converting the case from an 11 to a 7. But then the Chapter 7 trustee filed a motion to sell the complex, and they never sought a stay. And so at the end of the day, what the court said was, that by not seeking the stay, we can't give you your remedy. I mean, there were 363M protections in there, which are key when you go to sell, any assets in bankruptcy. And so for this one, really, I think, the takeaway is if you're wanting, if this is that important, seek the stay, put something of record and make people aware, that you've got to kind of protect your rights and not just sit back as an appeal is pending. A lot of issues come up. Where do you seek that stay? We've seen people go through all efforts, but at the end of the day, you start at the bankruptcy court initially, and then they might kick it on up to the various court of appeals, but that's where that case comes down. This one, Village Green versus Fannie Mae. I give this one creativity points. The court ultimately dismissed the case as bad faith. And what happened is you essentially had 3 creditors. You had Fannie Mae, who was owed about $8.6 million. And then the only other 2 creditors were the debtor's prior accountant and lawyer, who were collectively owed $2,400. And so in order to get the plan confirmed, under 1129A10, you have to have at least one impaired class vote for the plan. So what they what they did then is, rather than just pay the $2,400, which they had readily available from their budget, is they paid them out over time and categorized them as impaired. And then the lawyer and accountant accepted the plan, and so they said that they met the requirements for confirmation. On appeal, the Sixth Circuit reversed and said that that was clearly bad faith. I mean, that if you look at the determination there, I mean, that $2,400, those people could have been paid immediately, and that if you go to such extraordinary lengths with respect to a plan, that could not have been good faith. What was also in play at that point is Fannie Mae was owed about $8.6 million, and they proposed to pay them only down about $2 million over a 10-year time period. What the court pointed out is that, look, had they gotten relief from the stay, had they done other things, their indebtedness would have been reduced to about $2 or $3 million. And so I think the overall facts in that case, while very specific, but it does go into a good discussion about plan confirmation and good faith requirements. Under Leonard versus the Leonard case here, that one was sanctions. That is about a 60-page decision of bad acts related to a party. There was probably 2 years of ongoing litigation between the parties, and what had happened in the state court was that this party was sanctioned. The day before he was supposed to pay, he filed bankruptcy. The court then went forward and awarded the sanctions, and the debtor claimed that violated the stay, and the court rightfully pointed to 362B4, which this type of award and sanctions are accepted from the automatic stay. It goes into a lot of dialogue about the discretion of the courts. There was a lot of procedural back and forth about exactly what the sanction award was, what the fees award was. I don't know that I really see a lot of cases, at least in my practice, that go into it, but at least is a good proposition for one of the exceptions to the automatic stay. In Gandy versus Schuchert, the thing that this Schuchert was a creditor of Gandy who filed Chapter 7. Filed a Chapter 13. And from the get-go, Schuster, which was unclear to me, is what his claim was, because he went through extraordinary efforts throughout all of these proceedings to really stay on the debtor, and just kept at him and at him and at him. And at some point, it made me wonder, I think I need to look at the underlying case a little closer, but essentially what the debtor had done was claimed that he was not married, manipulated his monthly income, and did not disclose that he had bank accounts closed leading up to bankruptcy. And so he passed the means test, and then eventually bombed out of his 13, and it was converted to a 7. And so when he was converted to a 7, Schuster comes in once again and starts pointing out all of the inconsistencies with respect to the schedules. The court, and on the 7, then finally takes a look a little bit closer and realizes that the debtor had made multiple false oaths. I will tell you, one of kind of my pet peeves is when I look at schedules, I always question, this is signed under penalty of perjury, and when you see that there's just material things that are wrong, I always somewhat feel, who's looking at this? Is there really any accountability? At least with respect to this case, the court really does go into dicta and a discussion that, signed under penalty of perjury really does mean something, and they ended up denying the debtor the discharge in this case. Grossman is kind of the bad lawyer. I won't spend a lot of time on it, but he came in for for this condo association, started making all type of claims and litigating, and then ends up dismissing it, but had run up a legal bill for the debtor to about $132,000. The court then found that he was a vexatious litigator, which was a pretty extraordinary finding in the case, but it goes through the analysis of how you get the award of fees and sanctions in that context. I don't see a lot of that coming in, but to the extent that you have cases like that, I would be looking to that case. Higgins versus back home loan servicing, that really goes to an attempt at a creative class action against MERS. And what had happened was the notes were transferred to various MERS entities, but there wasn't an assignment of the mortgage. And the reason why there wasn't an assignment of the mortgage is because the transfer of the notes were between the MERS entities. People tried to make a lot at issue about MERS. I understand that there was some confusion and all of that, but at the end of the day, they tried to create a class action by saying that they violated Kentucky's recording statute. And the recording statute requires that an assignment of mortgage be recorded within 30 days of the assignment. And what the court properly did again, and this was, I guess, an example of the court once again confusing the distinction between a note and a mortgage, is they said that the mortgage was not in fact assigned, and so that really that there was a transfer of the notes. But it gives you an equitable interest in that mortgage, but that an equitable interest in the mortgage does not fall under Kentucky's recording statute. That it remained with MERS, and so that there was no assignment, and so they dismissed then the class action. But it does go into a good distinction between a note versus a mortgage when assignments, and then Kentucky's recording statute there. Bash versus Textron. That is a very large dollar case that went on for years and years. Fraudulent transfer. I would suggest that really it goes into a lot of Ohio fraudulent transfer law. So to the extent that you do practice in Ohio, that would be a good case to look to. The court goes through a lot of technical arguments as to statute of limitations, as to the 4 years, as to tolling, and all of those things under that law. I won't go into all the detail here, but to the extent that you really want to get into the tolling arguments and all of that, that would be a great case to look at there. In the city of Detroit, Michigan, that goes into equitable mootness. I would say that everyone wanted to talk about the the Detroit bankruptcy for quite some time. I would say I just read on the ABA headlines, I think the only thing that's coming as of late that's interesting is that Jones Day called the mayor a political hack, which I thought was an interesting move because he made a claim that he was perhaps going to look at their attorney's fees. I think there's a lot of questions about what went on in that case. I think it was an extraordinary result. I think it was great legal work, but apparently there is some looking at Jones Day and legal fees charged there, and they certainly weren't shy about coming out yesterday and making commentary. So I think to the extent, if you're in a Chapter 9, there's a lot of lessons to be learned. Otherwise, I kind of put these in the categories of Chrysler and GE, that these are just extraordinary cases that don't have a lot of applicability to our everyday practice. But I think it'll be interesting if Jones Days, in fact, if their fees are looked at or something gets reopened. So it's out there on the radar for things to be looked at. Grant versus Granador, that is actually just talks about the court's ability to reopen a case. I think it's largely the facts really kind of just drive this case. The woman then actually sought to reopen the case 4 years after it was closed. The court pointed to the fact that reopening the case really wasn't going to fix her issues in that case, that she had state law remedies, and it really goes into a good discussion just about the discretion of the court and that whether it can reopen a case or not. Holly versus Corcoran, that one really, to the extent we have Chapter 7 trustees in the room, this one is a beware for trustees, because in this case, what ended up happening, interesting facts, husband and wife is a bankruptcy practitioner and actually files a bankruptcy for her husband. He claims this unique Michigan exemption, which is tenant by the entireties. She then files her own Chapter 7, but they both are then claiming their residence and this exemption. And so they choose the state law exemption over the bankruptcy court exemptions, which they're certainly within their right to do. What ends up through that case then is there's all kind of fighting, and then they reach an agreement with the debtor and the house gets sold. Well, through all of the litigation, the trustee then runs up about close to $200,000 in fees, and getting with commissions and legal fees and all of that, getting the property to sell. And at the end of the day, then the court claims that under 522K, you can't tax exemptions to pay administrative claims. So now the trustee is sitting there and saying, the asset's been sold and I have no money to pay myself. And court kind of raises its hands. The court then really went out of its way to point to that we can't unwind the sale because there were 363M protections given to the buyer, so it's a bona fide purchaser. But that one leaves, I don't know how it ended up getting resolved at the end of the day, but it really did leave the trustee sitting in the lurch. Moving on to the BAP for the Sixth Circuit, N. Ray Tench deals with a tardy proof of claim. I think we all understand, the proof of claim bar date and how critical it is. What this creditor chose to do is try to file a motion under equitable considerations under Rule 906B1. And the bankruptcy court granted the motion, and the debtors appealed. And so then, the question for the court is whether an unsecured creditor is allowed to file a late proof of claim based upon excusable neglect. And the court, the BAP said no, that there is no code provision in Chapter 13. So this was a Chapter 13 for the filing of a proof of claim after the claim's bar date. And then they direct the discussion where it should be, which is to Rule 3002C, and they claim that that their creative use of 906B1 does not allow an extension of the proof of claim. So they did try to go out of their way that the precedential effect of the BAP's ruling was limited to this case and the parties, but to the extent, we all need a reminder about bar dates. That certainly is a good one. In Four Wells Limited, this case, what ended up happening was there was a languishing Chapter 11. And then the court set a hearing date for a motion to dismiss that was brought forth. And the day before that, the debtor then chose to file a plan and disclosure statement. The court held a hearing, did not consider the plan and disclosure statement, and dismissed the case, finding bad faith, and just dismissed the case outright. On appeal, there was kind of a split of what the bankruptcy court did. Is the court rightfully pointed out that that a bankruptcy case can be dismissed at any time. There's no magic or requirement that you have to have a hearing and a plan and disclosure statement. But then at the same time, it went forward and said that the court did not actually have good evidence, and there was not enough evidence before the court of bad faith. And so they remanded it for those reasons. But certainly it does stand for the proposition that when debtors make creative filings or try to put a plan and disclosure statement, it's not a reason just to delay addressing the substance of the case. In re Bratt, I felt like I was back in con law, in law school. This goes into the supremacy clause versus constitutional avoidance. And what you had was actually the legislature's attempt to get around a prior case with respect to interest rates for taxes. And so they created a statute that said if this specific bankruptcy claim, that there would be this additional interest and penalties for tax claims. The debtor then filed a Chapter 13, and the court found that the interest rate was this 18% interest rate as opposed to 12, and looked to this statute in Tennessee. And then the bankruptcy court overruled the objection of the taxing authority, citing the supremacy clause, saying that it contradicted with the bankruptcy laws. When it went up on appeal, the BAP affirmed, but for completely different reasons. They go into this large discussion about constitutional avoidance, saying that, that they should really avoid constitutional claims and issues as much as they could. And so they looked at the plain meaning of 11 U.S.C. 511, and they said that this was actually an applicable non-bankruptcy law and just assessed the 12% interest rate. But to the extent you get into those very state-specific taxing authority issues, I think it's a good case to look at. We get into In re Scheidler. This one really talks about actual and apparent authority for a debtor. What you had was a developer of a condominium project, and he put out marketing materials claiming that there was a builder on site, that the builder was available to custom fit the condominium, that it was, he was all of these great, wonderful things. So at the end of the day, this couple decides to buy the condo from the developer, but then hires the builder. And they put a deposit down with the builder, and then he ends up, absconding with the money. And interestingly, then the developer of the condo association files bankruptcy, and they try to sue him for non-dischargeable debts related to the builder. And the court goes through a significant analysis that they're separate entities, that really these marketing materials were just that they didn't necessarily rely upon all of them. So, to the extent that you look at reliance and non-dischargeable claims, and then it gets into the fact that the developer and builder, the developer was not an agent or really was not affiliated with the actual developer and did not have a parent authority either. So there's good discussions about those type of issues if you're trying to make a link between various alleged bad actors. In re Jones, this one, what the takeaway is that the party at issue, what they were pretty much sua sponte sanctioned for fees by a judge. So they made this judge very, very mad. He found no validity to the claims that they were litigating, and then just awarded fees himself. What the BAP then pointed out is that notwithstanding all of the bad acts, there has to be a motion for fees brought forth by some party, and that there can't be fee shifting in a sua sponte order. So I think, on remand, what that would invite is someone to file a motion, and then perhaps procedurally those fees would be awarded. But at least in a sua sponte nature, the court found that that was not allowed. In re Cursix, that gets into reopening of a Chapter 13 case as well. There were very technical reasons for that, but it's just another large discussion about the discretion of bankruptcy judges, and when you want to reopen a case, is it appropriate, is it not? I think we've all had those instances where something comes up and you look to that. This really, I think the case points out some good factors of what would justify reopening a case. So it stands for that proposition. It's worth looking at for that. But then largely, this case would really just be kind of more fact specific. Cassiano. This one was interesting. There was actually a fist fight outside of a bar. I don't know that we have a lot of those type of claims, but then it was a personal injury case, and they sought to sue, to seek non-dischargeability under 523A6, which is willful and malicious injury. The court goes into almost a comical analysis, though, and says that when the debtor punched him, that he didn't intend to cause the injury, and I don't know that it would really be applicable in our world, but the BAP took it very seriously and said, that the court improperly required the plaintiff show that the debtor desired to cause the specific injury, and that was just an unfair burden. But to the extent, willful and malicious, we largely use that, or claims that I've brought have largely been knowingly, fraudulently taking, lying to others, doing those type of things. I've not had a lot of cases where it is actually, fisticuffs, and whether that's willful or not. But it does go into a good discussion about A6 and certain factors there. In re Brunsman, that was up in Cincinnati. That was a very interesting case as far as background. Essentially, Brunsman is now in jail. What he did then was, with the ability to terminate UCCs, he essentially ended up obtaining loans from about 30 different lenders, which is incredible to me, but then releasing UCCs and pledging the same assets. This one, Rick Nelson, who I know and I have tremendous respect for, was appointed as kind of the liquidating trustee. It was converted from 11 to a 7. And this case then, I guess, involved certain of the aircraft. What ended up happening was he had filed, avoidance actions with respect to the perfection of the liens against the aircraft, saying that they were not properly done. But he had not himself, the trustee, just filed the avoidance action, and there was a hearing going on in some regard where actually the creditors had filed a motion for summary judgment claiming that they were properly perfected. There was no motion for summary judgment pending by the trustee, but Judge Perlman granted a motion for summary judgment in the favor of the trustee, saying, I deny the motions brought by the creditors, and then went a step further and said, because I've denied it here that they didn't properly perfect, he then just claims that that the trustee was granted a summary judgment. The court procedurally, the court then reversed Judge Perlman on that, saying that, look, you have to actually bring the motion, you have to give people notice that there was questions of fact, that just because the creditors didn't necessarily win a motion for summary judgment, it doesn't mean then that the trustee, that there aren't question of facts about what went on. But to the extent, you get into the procedures there, I think, there was just overreaching by the court in that regard. Let's see here. So in Ray Jackson, this one, the court, what ended up happening was you had a first mortgage and then a condo association with liens. The condo was completely underwater. The debtor goes in, obtains a discharge, and then the condo association, notwithstanding the fact that there was no equity, picks up with the foreclosure, makes clear that it's in rem, and wants to have the property sold anyway. The debtor came in and filed a post-discharge injunction, and the court granted it, saying that this was bad faith and that they did violate the stay because there was no hope of recovery for them, so that the only thing that this condo association could be doing was just tormenting the poor debtor. The court reversed, saying that the court abused its discretion, suggesting that, that just because they're exploring their remedies, the economic outcome isn't necessarily it, that they have to send a message. Condo associations have to see it through. There's other reasons for them doing this. But I think it's an interesting analysis about, the discharge rights and NREM proceedings versus personal proceedings. That I was actually happy to see, because I think we go out of our way when a discharge is obtained I think creditors should, and with NREM proceedings, there's always these kind of threats that are at least brought up to us, and we say, look, we put in the pleading, we're not trying to obtain any personal judgment in any way, but we still have to pursue the collateral. And so I think it helps not, with roadblocks not being put up. In Re Ramey, that was a pro se filing. I don't know if down here in Lexington and Kentucky, we have somewhat of a challenge with a lot of pro se filings lately by debtors. This case, though, just stands for the strict proposition that you have to do your credit counseling before you file. This debtor came in pro se, and under 109, she claimed she didn't understand, she didn't know, but it was just, the court was just very matter of fact about that requirement. On church joint ventures versus Blazagame, this really talks to the debtors were denied a discharge. They made the claims that, once again, concern me, that they hadn't read the schedules, that they didn't mean to mislead, that they really didn't have an understanding what they were doing in bankruptcy. But the court really goes through an analysis, once again, of how important the schedules are, that if they're materially misleading, that you do have an obligation to make sure that they're true and just, and then, that the creditors, it goes through the analysis of, they made a lot of excuses like, well, they really didn't harm them, and how did they rely on it? And I think the court really goes into a nice discussion there about, how creditors do look at the schedules, and largely this is sometimes the only information that they don't have the ability to access this information. They're left with the schedules. So I think it goes into a nice synopsis with respect to that. Moving on to the Eastern District of Kentucky, in Rogan versus J.P. Morgan Chase. This is a mortgage avoidance case that was brought in the context of a Chapter 7, and this was a defectively executed mortgage case. I think we've all seen those, dealt with it. But what we're seeing in a lot of cases anymore is that trustees are really kind of just throwing up their hands. This goes into the analysis that, look, even if it was defectively acknowledged, it put parties on notice, that there was constructive notice, and that there was not the ability to avoid the mortgage. And then the final case that we have is NRA Back, and this goes into actually a creditor, like you have the 15-year statute of limitations in which to execute on a judgment, and it goes into a good analysis about what things can be done to toll that statute of limitations or to comport with it. And so what they claimed is that the creditor was time barred because they filed a motion to intervene, but the motion to intervene wasn't granted within the 15-year time period. But the court rightfully looks at it and says, well, they're executing on the judgment by taking the steps to file the motion to intervene, and so that constituted executing on the judgment, and so that the creditor was not time barred. I think we run into that a whole lot with time frames and taking the steps, like if you file the motion, if it's not granted by that time, it goes into a good analysis under the bankruptcy courts about those type of claims and issues that they arise. But certainly, the creditor was active and in the case in operating, within the statute of limitations on that. So with that, I don't know if there's any questions, but certainly I appreciate your attention and look forward to the rest of the conference.